All right, welcome back. We are back in court this week. We've got one judge, Judge Bentley Price out of Charleston, that's going to be doing the trials this week. And of course, he sat down with the jury. When you get a jury summons, you come in. There may be a couple of hundred people that would be here under jury summons. So the first part of Monday is to sit down and to go through a list of questions with all of those jurors en masse to see who is qualified to be a jury and on the jury and who would be unqualified. And then there's some gray areas. So I get this question all the time, but I'm 65 and I've got a summons to come to jury court. Just by being the age of 65 doesn't mean that you won't get summons to come. What it means is that you can tell them, look, I've made it to enough time in years, and I wish to serve or I don't wish to serve. The only other real way to do that is to say almost from the beginning, once you reach this age, we won't bring you in anymore. But some people that are 65 would like to serve. So it happens every time. They basically get a choice. The judge says, hey, you've made it to 65. You could qualify for this exemption. Do you want to take it? And depending on what the case is, they may say, yeah, I don't want to sit on that case, or yeah, I would love to sit on the case. So, but there's a lot of questions, and in other parts of the United States, they have something that's known as voir dire, which means that the defense gets up and asks a series of questions, and the state asks a bunch of questions, and you're trying to get a read for how you think this person would be on a particular case. The only time we do that in South Carolina is on death penalty cases, and that's why they are brought in panels, and those go on well into the night, going with each panel and trying to figure out what each particular juror is thinking. In most court, all that's going to be asked of you is, where do you work? Are you married? Where does your husband or wife work? Very preliminary questions, and from that we would get a gauge on you. So it goes a lot quicker in South Carolina courts than it would in other states. Remember OJ's case, it took 6 months. The longest case we've ever had was Murdoch, and that took 4 or 5 weeks, which was outstanding for a South Carolina case. Most death penalties are over in 2 weeks once the jury is picked. So, and the longest part of that is the voir dire. I've literally been out here at night before on death penalty cases to 2 and 3 o'clock going through jury list and then have to get up and start the case the next morning. So Judge Price is doing that down the hall right now. In another courtroom, there's a judge called Robert Bonds, and he is taking jail cases on Monday. So people that are locked up in jail that haven't been out on bond, he will take a bunch of those cases on Monday, and then we'll go into team days on Tuesday, Wednesday, and Thursday, and he will take a bunch of pleas in courtroom here at the courthouse. Also today, our drug team, this is the first time in probably a year and a half that we've started off with a drug case. Most of those cases plea, but this is one of those cases that did not plea and now is looking at mandatory minimum 25 years in prison, which leads to another question, and we get it all the time. How can somebody get so much time for drugs where maybe someone lost their life and not get as much time? That drug statute is tremendous, and it would take an Albert Einstein or a Philadelphia lawyer going through and reading it to figure out the different nuances of the drug law. It's literally a book of statutes. So much so that we years ago did a cheat sheet, basically. And what you'll see is that the possession cases are up here. If you had a small amount of cocaine, you would be charged with possession of cocaine. And possession of cocaine for the first offense could carry as little as time served, or it could carry as much as 3 years in jail. Crack is the same statute, 0 to 3 years. Second offense, you've had cocaine, you've pulled a few days in jail, you've got a record for it, you get caught again, it carries up to 5 years in jail. So it goes from 3 to 5. And then every third or subsequent offense of possession carries up to 10 years in prison. But there's no mandatory minimum on it for possessory cases. The next step up is possession with intent to distribute or distribution, actually selling cocaine to get money. And for a first offense of selling cocaine or having an amount that's large enough that you could sell it over an ounce, over 1 gram but less than 10 grams is the thing for possession with intent. That carries up to 15 years. But if you had a possession case and now you are charged with possession with intent or selling cocaine, you could go from 5 years to 30 years. So there's a mandatory minimum of 5 years on that, but it goes up to 30. And then you can see where the next level above distribution or selling is trafficking. And trafficking is just what it sounds like. It's a big amount of cocaine. And those weights are based on, or those sentences are based on how much it weighs. But it's possession of a bunch of cocaine or a bunch of crack cocaine. And for a first offense, trafficking in cocaine or crack, mandatory minimum 3 years in prison, and it goes up to 10. Second offense is 5 to 30, as I just mentioned, and a third offense is mandatory minimum 25, but goes up to 30. So all of those sentences that you see where we're getting 15, 20, 25 years, it is generally crack cocaine, cocaine or heroin, but it's second or third offense. So that's how the sentences are compounded by your having priors. But nobody gets a first offense, possession of cocaine or possession of crack cocaine or possession of heroin, and goes to prison. The law will not allow them to go to prison for those huge amounts of time. It's a second and a third and a fourth and a fifth offense. And, somebody is sitting there today saying, why in the world do you let it get to a third? I don't get to write the laws. That's for the legislature. The legislature says what they believe a second and a third and a fourth offense of trafficking should carry. And then it's up to us to enforce it and the judge to make sure everything is fair with the trial. So this is the graph that we sort of go through, and it would not be uncommon for a person that is really there for a trafficking third offense to be able to plea as though it was a second offense, so that they could get from 5 to 30 instead of 25 to 30. And that's where you see a lot of those sentences of being 15 and 20 years. It's the sentence is been reduced so that they would plea, and that case, all of those cases wouldn't have to be tried. We only get 26 weeks of trial during the course of a year, and we try to hold those for rape, murder, and kidnapping. But sometimes, like this week, it's the first time in a year and a half, we'll start off with a third offense trafficking type case. I'll update you on how this case went this week. Of course, they're just picking a jury now, so we'll figure it out and let you know next week what went on with this case.